The only problem is the judge and the prosecutor both are, well, the judge running for re-election, the prosecutor's running to be a judge, so they're going to try to use my shit because it's so high profile shit to make them look good. So I'm pretty sure I won't get much of an offer at all.
So dumping pee on the grave was whose grave? Who's he talking about?
He's talking about the daughter.
What
and
daughter?
Not her, not Kimberly.
The daughter's alive.
I know. They were talking about it.
Okay. This is 24 DCCR 1369, and sir, you're Terry Rose.
Yes, ma'am.
And Mr. Rose was previously in court, entered a plea of guilty to the offense of murder, and the agreement was for a cap of 40 years in prison. I received the pre-sentence report as well as 2 letters that Mr. Burbank submitted. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor. Defense has, Judge.
Are there any additions or corrections to the pre-sentence report?
Not from the state, Your Honor. Not from defense.
All right, then, Mr. Mr. Burbank, do you have any witnesses?
Subject to rebuttal, Judge.
Okay, so you're fine with the state going first?
No, we'd ask, yes.
Okay.
We ask you to take judicial notice of what's in the deed.
I will do that as well. All right, Mr. Nichols, you have witnesses to call?
Yes, Your Honor, I did.
You may call your first witness.
Oh, Captain Michael Ponder, Your Honor.
How are you, sir?
Oh, she's not swearing.
Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat. You may proceed.
Thank you, Your Honor. Captain Ponder, would you introduce yourself to the court, please?
Yes, my name is Michael Ponder. I'm the captain of the Jefferson County Sheriff's Office, and I'm the custodian of records for Jefferson County Sheriff's.
What are your day-to-day job duties?
I oversee all records that we maintain, both physical and digital records, everything from physical paper copies of inmate records to phone calls, messages, video recordings.
And at the Jefferson County Jail, are all inmate communications recorded?
Yes, sir. All telephone calls made from inside the dorms are recorded.
And can you explain to the court how that system works?
It is an automated system. Whenever the inmates make a call, they have to verify their inmate ID number with a personal PIN number that they create. And it also has a voice PIN authenticator that has to match their voice to what the system has on file.
And are all those calls recorded?
Yes, every phone call that's made from the facility has a prompt whenever they first make a phone call stating that all phone calls will be recorded.
And is there an outside company that runs the technology and runs that system?
Yes, it is a company called Smart Communications. They maintain our phone systems.
And as the supervisor for inmate communications at the jail, are you a custodian of records made by that company as it pertains to inmate phone calls?
Yes, sir.
Is the system capable of making accurate recordings?
Yes, sir.
May I approach, Your Honor?
Yes, you may.
Showing you what I've already marked as State's Exhibit number 1 for purposes of this hearing. This is a thumb drive. Have you had an opportunity to review this earlier today?
Yes, sir.
And State's Exhibit 1, it is a recording of an inmate phone call, correct?
Yes, sir.
And can you identify the inmate who made this phone call?
It was Terry Rose.
And it was made on the 17th November 2025, is that correct?
Yes, sir.
Is this a true and accurate copy of the phone call made by Terry Rose?
Yes, sir.
And as a custodian, you can identify this for the court and verify that this is, in fact, Terry Rose making a phone call from the jail.
Yes, sir.
Your Honor, at this time, I'll offer an evidence State's Exhibit number 1.
Your Honor, I've been provided a copy and no objection, states 1.
States 1 is admitted.
And Your Honor, I will publish it later in the hearing.
Okay.
And I have no other questions for Captain Ponder and the best witness.
Thank you. Any questions, Mr. Burbank?
Just several questions, Judge. Ma'am. Good afternoon.
Yes, sir.
How you doing? How many phone calls, you're the custodian of the record, how many phone calls has Mr. Rose placed at your facility?
I can't tell you the total number. I haven't looked at every one of them.
Well, how much do you, more than one?
Yes, sir.
More than 100?
I couldn't tell you exactly, sir.
Well, because they're only asking about one phone call, correct?
Yes, sir.
And so my question is, through your being the custodian of the record, Would you acknowledge that he has made numerous phone calls since he's been at your facility?
I can't tell you how many phone calls he's made, but he has made phone calls at the facility.
Okay, well, let me ask you this. You were requested by the district attorney to retrieve the phone calls of Mr. Rhodes, correct?
Yes,
Okay, who did that? Did you do it, or did you have someone else do it?
I just verified the phone call came from our system. It is pulled from the DA's office.
Okay, so the DA's office has the number of calls that he made at that facility.
I can't tell you how many calls they called. I was only called reference to one.
So out of all of them, if I represent to you, they had numerous calls, they've only asked you to testify to one.
Yes.
And do you know who he was talking to?
No, sir.
Do you know who he was talking about?
No, sir.
And do you know how long he's been at your facility?
Not the exact time, no, sir.
You don't know when he was booked in?
No, sir.
Thank you. Pass the witness, Your Honor, subject to recall.
Thank you. Anything else, Mr. Nichols?
I have another question for Captain Ponder, Your Honor. I'd ask that he be allowed to return to duty.
Do you really anticipate any other questions, Mr. Burbank?
I don't foresee any, Judge.
If we need you back, Captain Ponder, just make yourself available, but you're free to go. Thank you.
At this stage, the court is doing something very specific. The jail officer's testimony isn't about guilt. That's already been resolved. This is about foundation. The state is establishing that the recording you're about to hear is authentic, complete, and attributable to the defendant. In sentencing proceedings, reliability matters as much as substance. Once the call is properly admitted, the court is permitted to consider not just what was done decades ago, but how the defendant speaks about it now. And that distinction becomes critical.
Your Honor, I'd like to publish State's Exhibit 1 at this time.
Sure.
Thank you. Please remain on the line. Hold for acceptance. This is a prepaid call from
Terry Rhodes.
your call has been accepted.
Hello? Hey, I don't know. Maybe she just don't want to have to deal with this trial and trying to hide and stay away from it because she don't.
Your Honor, for the record, I have forwarded to just past the 10-minute mark on this phone call to play my portion.
Okay.
Like all this stress and shit. I hear that. But I don't know. I'm gonna just let it go for a while. My trial is, my pre-trial is December the 8th. I'll go down there and hopefully they'll make me an offer. If they will offer me 25, I'll sign on that and we'll be done. If they try to offer me anything else or they don't offer me anything else, well then we'll just go to trial. Yeah. Because, trial is like 5 to 99. Okay, I could get as little as 5 years or as much as 99. They're not going to give nobody 99. I'm not like a psychopath, sociopath, crazy ass, I'm not none of that. I had a bad day, I dealt with it wrong, I fucked up, and I'm got to deal with it. So, the only problem is the judge and the prosecutor both the judge is running for re-election, the prosecutor's running to be a judge, so they're going to try to use my shit because it's so high profile shit to make them look good. So I'm pretty sure I won't get much of an offer at all. Because that 40-year offer was like an insult. I'm 68 years old. 40 years, you got to do 20, so I'd be 88, and then I go before the parole board, and Tiffany's going to be there to say no, and then I got to wait another 6 months and go again, possibly. I'll be fucking 90 years old before I get out, and then I got to deal with parole for the rest of my life? Oh, fuck no. No, I'm sorry. I'm not accepting.
Oh, man, she's in her 40s, people die in their 40s and 50s all the time.
That'd be sweet.
I mean,
Yeah, that'd be sweet. I will pee in a cup, send it to y'all to pour on her grave. I'd do that. You good lying bitch. Oh, yeah, I'll fix her right up. Since she would have been honest and said, look, I was out messing around on you, I could have just walked away, not had a problem, and none of this shit would have been a problem. But no, she had to keep her mom's secrets You know, I didn't know, I kind of suspected one, but I didn't know she had a fucking harem. But anyway. So I don't know.
State of Texas rests, Your Honor.
Thank you, Mr. Burbank.
Your Honor.
Thank you, Mr. Nichols. Mr. Burbank?
Jail calls are often introduced as mitigation. This one does the opposite. From a legal standpoint, the problem isn't profanity or anger, it's perspective. The defendant minimizes the offense, externalizes blame, and frames the consequences as an inconvenience to himself. In sentencing, remorse isn't measured by words like sorry, but by accountability. When a defendant's own statements reveal entitlement or contempt for the process, the court is entitled to weigh that as an aggravating factor.
As you well know, we've been doing this a long time, Your Honor. I guess I longer than you, and there are no winners in this case. Problem with this case is that it was, I guess, called upon or detected or police were notified and she was found. It might have turned out differently, or there were other facts and circumstances that might have arose. There's a couple of things I'd like you, but it didn't. And no matter how you look at it, Your Honor, if there were facts and circumstances at the time of this incident, they are bygone and they're not here anymore because of the 25 years of where that person was, Kimberly was placed. And that's the sad part about this. When you look at this and you look at people in reference to representing him as a defense attorney, I look at things. For instance, in State's Exhibit number 1, I wanted to make sure that the court realized that no matter what, he was not talking about Kimberly Langwell. He was talking about the daughter. And as the court is well aware, there is also a civil trial going on in reference to, with her family.
So dumping pee on the grave was whose grave? Who's he talking about?
He's talking about the daughter.
What
and
daughter?
not her, not Kimberly.
The daughter's alive.
I know, they were talking about it.
Okay.
And it had to deal with the civil case that's currently pending.
Okay.
It was not
Okay.
for Kimberly. And it's reflected in that, Judge, in reference to things that supposedly she should have done about telling about Mom. You have a gentleman here, though, unlike a lot of other cases that you see before this court, that has no record. He has gone 68 years, and there is no record. There is nothing there that says he's lived a troubled life, in the sense of that he's had a secret. He has, and I asked the court to take judicial notice of the 2 letters that were written, one from his aunt and one from his daughter. One of the things that I believe that was brought out, he is relieved at what happened. It has been eaten on him, just as Mr. Riley. He's sorry for what he did. He's tried to explain within the PSI and in reference to the version that he has given. I can't tell you what, if any, consideration that you may be able to give him based on the ultimate facts and what's happened. But you have an individual that has not been in trouble, that has been employed, except he kept a secret. And he kept a secret to the detriment of a family that was grieving at the time, and wanted to know where their loved one was, especially a 15-year-old girl, and that he can't erase. I would ask for any consideration, if any, of course, of his age, because of the nature of the offense of being 3G under the Texas Code of the Penal Code. and Texas Code of Criminal Procedure. So any consideration that you might give, but there's a cap of 40. Thank you.
The defense is now asking the court to narrow its focus. They emphasize age, lack of criminal history, and the absence of prior convictions, all legitimate considerations under sentencing law. But mitigation has limits. A clean record does not neutralize post-offense conduct, and it does not outweigh decades of concealment. The court isn't deciding who the defendant was before the crime. It's deciding who he has shown himself to be since, and whether mercy is supported by the record.
Thank you, Mr. Burbank. Mr. Nichols, can you play that again for me, please? I just want to make sure
I can, Your Honor. I'll represent to the court. He's not talking about Kimberly Langwell.
Okay.
And I'll make it part of my argument.
Okay, go ahead then.
The phone call you heard, Judge, was him talking about how it greatly inconvenienced his life to have to deal with the parole board should he ever make it that far. And that no doubt Tiffany McGinnis would tell the parole board not to let him out early. That's what he's complaining about. And his son, who's the other end of that phone call, mentions, well, maybe something will happen to him and she'll die. She's in her 40s. And his response to that is, I would gladly pee on her grave, Your Honor. And the reason I play that, along with a lot of the other evidence we heard today, shows this man has no remorse, no feeling whatsoever for what he did to Tiffany's mother and what he's done to this
Don't talk,
family.
if you want to testify, you can get up here and testify. Otherwise, you have refrained from doing that, and so stop talking.
And on that call, he blames a then 15-year-old girl for not telling him that her mother had moved on. And that's sick and twisted, Your Honor. No more sick and twisted than living in a home with your murdered ex-girlfriend under your floor. A home that he later shared with his common law wife. A home that no doubt people came and went in for the last 25 years. With Kimberly Langwell buried in a shallow grave under a pillar. Every step of the way has been a slap in the face to Kimberly's family. Every step of this is just inhumane. To go there the next day and open up the car for them, knowing what you did. To tell somebody and expect them to keep the secret for 25 years. To put up a billboard and pretend you're trying to help find her it is vile, it is inhuman, and it is not worthy of any consideration from the court, Your Honor. The cap is 40 years because of his age. And I'm asking the court to enforce that full 40 so Terry Rose spends what's left of his life behind bars, Your Honor, because that's what he deserves. Thank you.
Thank you, Mr. Nichols.
You want us to rise, Your Honor?
I don't care. It's not often that I'm at a loss for words, and honestly, it's because I have too many words. And anything I say is not going to help Tiffany and her family other than getting this over with, which is why I pushed this to get done today and not wait until the end of the year or the first part of next year. But there's just certain things that I can't even look past to not point out. The fact on that phone call that you said you're not a psychopath is just beyond me. Who isn't a psychopath that kills someone that they once cared about and buries them in their house and lives on top of them for 25 years? I would think that's the definition in Webster's dictionary of a psychopath. It's not a bad day. It's a bad 25 years for her. I mean, it's the nonchalantness about how you spoke about this told me way more than I really needed already with what I had. But that is just the fact that you think for some reason that me running for re-election or Mr. Nichols running for election has anything to do with what we're doing today. It does not. You can ask anybody here, any of this law enforcement, I've never made a decision because of politics, and I never will. And Tiffany's right. 40 years isn't enough. There is a part of me that wishes I had not accepted this plea agreement and that we had gone to trial last week, because I do think a jury would have given you life for 99 years. I actually do. If they had heard that, you would have gotten that. And the fact that you thought you wouldn't is the most narcissistic thing I think I've ever heard in my entire life. So, there's just so much more. The billboard, it's insane. It's psychotic. That's what it is. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I hope that today gives Tiffany at least some final closure on all of this and her family. I'm going to sentence you to a term of 40 years in the institutional division of the Texas Department of Corrections. If I had 50, I'd give you 50. If I had 60, I'd give you 60. Whatever it was that the cap was going to be, after hearing all this, it would have been whatever it was. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was an agreement, so you have no right to appeal, which also is one of the only reasons that I accepted this plea agreement, because that does make this final. So there's no appeal, there's no chance of anything happening, it's over. I highly doubt that this matters, but I am required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about that, you can talk to Mr. Burbank about how long it is or the eligibility. Again, I don't anticipate that being an issue. I want to thank every single law enforcement officer that's here, really on behalf, I think, of Tiffany and the family as well, Mr. Nichols and Mr. Canal, for the work that's been put in for 25 years to finally get this taken care of. At this time, you can go with the bailiff.
By the time the judge delivers sentence, the analysis is complete. This is no longer about speculation or sympathy. It's about credibility, conduct, and consequence. The court expressly rejects the narrative of a single bad decision and instead recognizes a sustained course of behavior that extended for decades. In imposing the statutory maximum, the judge is not reacting emotionally. She is applying the law to the facts before her. The waiver of appeal underscores the finality of that decision. In legal terms, this sentence reflects both punishment and protection. Punishment for the crime itself, and protection of the integrity of the judicial process. This is what sentencing looks like when accountability, not excuse, controls the outcome.